So thank you all for joining. Today we'll be going through our Tag Inspector webinar, CCPA Enforcement, specifically how marketers can prepare. So with that, we'll go ahead and kind of jump right in. Quick disclaimer, as with everything, this is meant to be educational. We want to really, talk through CCPA, some of the different requirements, and as mentioned, how marketers can prepare, but it's not meant to be legal counsel. Ultimately, any decisions that are made by the organization need to be vetted, approved, and then actually implemented by your own in-house legal counsel. So yeah. Also, kind of general housekeeping, as we're going through this, please just ask any questions directly as we go through. There should be a Q&A bar within the Zoom conferencing or the Zoom meeting. We monitor those as we go through. There will be time at the end for Q&A, but I'd like to keep it as helpful as possible and as kind of conversational as possible. So if you have any questions, please drop them in there. If it's relevant to the slide or the topic that we're talking about as we go through this, you can kind of dig into them at that time. Perfect. So CCPA, what we're talking about today, California Consumer Privacy Act. So January 1 of this year is when the CCPA actually went into effect. Now, July 1, the upcoming date of 2020, is when the CCPA becomes enforceable. So when state action can be brought. Now, a lot of people have questions, what does this mean? How does something go into effect on January 1? It doesn't become enforceable until July 1. What's kind of the difference between the dates? So technically, the restrictions and the requirements for organizations are in place today, and individuals can bring what's called the private right of action as of today. We're actually already starting to see some of those. So in terms of the current requirements today, as of May 27th, the current requirements of what's active now, as far as what you can be penalized for, are mostly centered around data breach. So what is possible here with data breach and what's outlined within the CCPA is consumer action can be brought. What that consumer action can be brought regarding are any data breaches and then damages that are associated with those. So statutory damages if consumers' information is subject to a data breach. There are a few requirements for what would constitute a data breach. It must be, all three of these requirements must be met. So personal information as defined within California's data breach notification law needs to be breached or accessed by an outside party. Those are specifically listed within the law. A really important note here is that what those categories of personal information are is actually a narrower definition than what is outlined within the CCPA. So it's much more specific. It's more around like clear text, PII, traditional PII type of information. But those are listed there. Personal information must be non-encrypted and non-redacted, so basically clear text. And then the breach must be the result of a business's violation of the duty to implement and maintain reasonable procedures and practices appropriate to the nature of the information. I'm not going to get too deep into these data breach requirements, more so just wanted to let you know that yes, there are some requirements your business can be penalized under the CCPA as of today. These data breach items are more focused for like the security backend folks within your organization. What we want to focus on is more of, again, what marketers can do today to prepare and make sure that everything is in line. A note though on those data breaches, there are two different penalties that are kind of really made possible under the CCPA. For these data breach penalties, the right of individuals to file that private action, they can recover between $100 and $750 in statutory damages per incident or actual damages. So this is on the lower end of those different penalties. Now, as mentioned, this is something that is currently in place. So actions have actually already been brought. The most kind of pressing one, or the one that has got the most press, was a complaint filed back in February. Punitive class action lawsuits against Hannah Anderson and Salesforce, which alleges negligence and failure to maintain reasonable safeguards. Basically, what happened was there was a breach of information due to data scraping from hackers on the website, in which they were scraping names, addresses, payment card numbers, CVV codes, all of those items as individuals were kind of checking out. So for this breach, it happened in 2019. Users were notified of this in 2020. Class action lawsuit was brought and filed back in the beginning of February. Now, this is still ongoing. There's some questions that are really raised by this particular case. There's no really look back window on the data breach requirements. So there's questions of, is it actually kind of valid under the scope of CCPA, as well as there's the technicalities for giving the organization 30 days to rectify the breach. So some questions that should be answered as a result of this lawsuit. But just to keep in mind, the data breach requirements as outlined within the CCPA are currently active as of January 1. Action can be brought. So any PII type of information being collected on the website is really leaving open the risk of penalty. So what's the difference between that, which is currently active, and then the general enforcement, which is what begins in July 1? So as of July 1st, 2020, action can be brought against a business by the State Attorney General of California, State Attorney General's Office of California. This enforcement surrounds non-compliance with respect to users' rights as are outlined in the CCPA. Now, this is where, from a marketing standpoint, this is what we're really trying to prepare for, make sure all of our ducks are in a row for. So the penalties for non-compliance with respect to users' rights, state action can file up to $2,500 per violation if non-intentional, up to $7,500 per violation if intentional. Now, these numbers seem to be kind of pale in comparison to those offered the penalties under something like the GDPR, for example, in Europe, if you are an international organization. What's important here is that these fines would be per violation. So say, e-commerce website, you have 1,000 different users that are going through and loading a particular page or converting, buying something on the website. For each 1,000 of those individuals, you're not respecting those privacy rights, those users' rights as outlined in CCPA. Even if it's a non-intentional violation, if that's happening, each one of those 1,000 users would constitute a violation. So in that case, your punitive fine here, or the action against you, could be brought for $2.5 million. Those numbers can obviously accelerate very, very quickly. And that's why this is really serious business, to make sure that we're in compliance with CCPA. So as far as those rights that we need to make sure that are being upheld, what exactly are they? So really simplified down under the California Consumer Privacy Act, it outlines 5 rights that are afforded to Californians with respect to their personal information. So number 1, they have the right to know what personal information is being collected about them. Number 2, they have the right to know whether their personal information is being sold or disclosed, and if so, to whom. The right to say no to the sale of any personal information, the right of Californians to access personal information, and then the right to equal service and price, even if they exercise their privacy rights. So these are the rights that we need to make sure are being upheld. And if in violation of any of these different rights, then that is when those different actions can be brought forth. And again, that could be brought forth beginning on July 1 of 2020. So kind of taking a step back a little bit, I want to do a very high level overview of CCPA. What are some of the different requirements in there, just to make sure that everyone's on the same page, as we then start talking about some of those specific things that can be done in order to prepare. So first, the CCPA, who exactly does it apply to? Businesses with consumers in the state of California that meet any one of the following criteria. So if any of these criteria are met, then your business would be subject to the requirements as outlined within the CCPA. So the first one, gross annual revenues in excess of $25 million. Also would apply to you if you annually buy, receive for commercial purposes, sell, or share personal information of 50,000 or more consumers, households, or devices. And then also if more than 50% of annual revenues are derived from the selling of consumers' personal information. If none of these criteria apply to your business, then the requirements as outlined in the CCPA aren't applicable. That said, there are a number of additional states that are starting to introduce legislation very similar to the CCPA. There's the possibility of a codified federal law restriction around privacy, and the CCPA was being put into place as a result of kind of the winds of change amongst users and amongst consumers. Your users are expecting very basic and kind of foundational privacy rights to be upheld and respected by the organization. So even if these different damages and the different penalties might not directly apply to your organization, because as of today, you don't meet these requirements, it's still really important, and it would behoove everyone to take note of what the requirements are and then start taking those steps and the strides to actually following and being in compliance with these different regulations. So CCPA, who does it become enforceable against? So CCPA applies to you if you meet one of those different criteria, and then it is enforceable against a business that collects consumers' personal information, collects personal information about a consumer or about consumers, sells consumers' personal information or discloses it for a business purpose, sells personal information about a consumer to a third party or to third parties. So beyond just those requirements of who it applies to, it then becomes enforceable against any business or organization that is collecting or selling, basically to summarize, users' personal information. A few important definitions just to go through so we're on the same page as we walk through some of these different requirements and then what it is specifically that you could be doing. So when we talk about collection of personal information, we're talking about the buying, renting, gathering, obtaining, or receiving information about the consumer, either actively or passively, or observing the consumer's behavior. This is bolded, it's highlighted for the reason that as marketers, many of the different marketing advertising technologies that are in use across your websites are going to be observing consumers' behavior. It's how we understand how users are interacting with the website, what they're doing, tracking analytics, all of those different things. So collection of any personal information, any data points that fall under that definition, by its very nature of our marketing and advertising technology stack, that's collection as defined under the CCPA. Selling is the selling, renting, releasing, disclosing, making available, transferring a consumer's personal information by the business to another business or a third party for monetary or other valuable consideration. So basically, if you are, selling or disclosing consumers' personal information to another third party for any type of financial return, that's going to fall underneath that definition of selling under the CCPA. When we talk about personal information, personal information under the CCPA is extremely broad. So anyone that's already gone through preparations and kind of enforcement for GDPR, for example, the definition of personal information for the CCPA is broader than that definition. Personal information as defined in the CCPA is any information that identifies, relates to, describes, or is capable of being associated with or reasonably linked directly or indirectly with a particular consumer or household. This explicitly, as outlined in there, includes internet activity, including browsing and search history, as well as web tracking data. So any type of, again, marketing, advertising type of platform that we're leveraging on a website, on a digital property, is basically any information that can be associated with a user is going to fall under this definition of personal information. When we talk about just how web marketing advertising technologies work, by their very nature, take your analytics platform, for example. they're going to be collecting, even if it is an anonymous, unique identifier of a user, that is going to be sent up with every single hit. So all of their, what pages they're viewing, what buttons they're clicking, what conversions they're doing on the website, all of that information is being collected with some sort of a unique client ID. That client ID is something, even though it's unique and anonymous, it can be associated with that consumer or that household because it's associated with a specific browser. So anything that's not basically fully anonymized, aggregate, statistical type of information is going to fall under that definition. Very broad definition of personal information, and which means that most of our marketing and advertising platforms are going to be collecting at least one data point that's going to fall under that definition. So it means from a marketer's perspective, we need to be taking these things extremely seriously and really thinking about the requirements for all of the different platforms that are being leveraged. Finally, definition for consumer, any natural person who is a resident of California. This applies to California residents outside of the state as well. So as far as the requirements go, there's really three core principles to really simplify this as we think about the requirements. So we talked about the different rights that a user, that are afforded to Californians under the California Consumer Privacy Act. The three core principles, the first one is around transparency and disclosure. Users have a right to know what information, if personal information is being collected about them. If so, what is that personal information that's being collected, by whom, where is it being shared, all of that. So there needs to be transparency and disclosure of any of that activity that's happening. That disclosure, as outlined, needs to be provided in two different places. First, at the point of collection. In the CCPA, it talks about having some sort of a banner, some sort of a notification on the quote-unquote homepage. The homepage, we can think of it from more kind of marketing parlance, would be any landing page. Any page that a user's on, there needs to be some sort of a notification if personal information is being collected about that user. Also, very specific requirements are necessary to be reflected in your privacy policy or the notice. Now, these are outlined specifically within the CCPA, exactly what needs to be included in there. There's a couple resources on the Tag Inspector site that list those out as well to make that a little bit easier. Your legal team should know exactly what these different things are. Touch on it a little bit here as we continue on our discussion here today. In addition to that first principle around transparency and disclosure, second principle is around access rights. So a user has the right to request information, to request for you to provide or access their personal information that you have collected about them. There's a concept in there of data portability, so it needs to be in an organized manner, but they do have those different access rights. So that's really the second principle that we need to keep in mind. And then third, users have a right to the refusal and the objection of processing. Now, for purposes of the CCPA, they have a right to refuse the sale of personal information. That right does not extend to collection, nor to just the general processing of personal information or personal data, similar to like what would be in GDPR. Under CCPA, users have a right to opt out of the sale. Now, from a technical like tag management standpoint, in many cases, if you are selling personal information, the easiest way to cut off the sale of that is either one, to change the general business strategy, but across many platforms, it can often be a little bit difficult to exclude specific users or specific records from any sale that's happening. So oftentimes in practice, what this means is when a user opts out of the sale, organizations are architecting this to cut off the collection point. Because at the end of the day, if you never have that personal information, you can't sell it. So that is the third principle, just around the right to refusal and the objection of processing. So let's dig into these a little bit further. So first, users have that right to understand what personal information is being collected. So you must provide notice to consumers at or before data collection. As mentioned, this really falls into two different categories. So a banner or notice on page. Within that banner, the user needs to have access to view the categories of personal information that are collected. Those are outlined specifically within the CCPA. And then also needs to know the purposes for collection. So what is it that you're doing with the personal information that you're collecting about them? Why are you collecting this? How is it being used? That's what needs to be disclosed or at least available to the user through that banner or that notice on the page in any of those cases where personal information is being collected. Secondly, transparency disclosure needs to happen. Users need to be notified via the privacy notice on the website or available within the website. Specifically within that privacy notice, you need to cover the categories collected, specific data that's collected, if it's shared, if it's sold. We need to list the rights of users. It needs to be in a form that's reasonably accessible. It needs to be upgraded or updated constantly every 12 months at least. And then also there's a draft regulation that you must disclose financial incentives offered in exchange for retention or sale of a consumer's personal information, how that value is calculated if you are offering any of those financial incentives. There's a number of additional requirements, as mentioned, very specific to CCPA for the privacy notice. We're not going to dig into those too much here today because we have in past webinars, and then also some resources that are out there if you want to dig into that a little bit further. In addition to those notification requirements, we also need to, within our organizations, create procedures to respond to consumer requests to opt out, to no, or those access requests, and then also for deletion of any personal information, as users have a right to request that as well. These procedures for opt-out, no, and delete. So the first one, as far as no or access, the user's right to know what personal information is collected about them. They have the right to receive answers free of charge within 45 days of the request being made for the 12-month period prior to the request. This is where look back kind of comes into play within the CCPA. So even though enforcement begins on July 1, if a user conceivably requests the personal information that you have, requests to know what personal information has been collected, processed, sold, shared, all that, you would need to provide that for the most recent 12 months of information. Now, there is some, I guess, debate. Would this extend beyond just that January 1 time period? Even if not, it's going to, because CCPA was in effect from January 1, you're going to need to at least be able to provide the most recent 6 months. So we need to really dig in, understand, what personal information is being collected, have that in a format, and make sure that we have the processes in place to be able to provide that. This needs to be in a readily usable format that the consumer can transfer to another entity without hindrance. We also need procedures for opt-out. So consumers must have explicit notice and an opportunity to exercise the right to opt out before any selling occurs. Again, in practice, it can be very difficult across different platforms to opt out or to remove individual data points from overall batches of information that are being sold. For that purpose, in practice, many organizations are cutting off that at the collection point. So if a user is opting out of the sale, from a practice standpoint, organizations are also just stopping the collection of that personal information, which is a little bit more the safer route. But we need to have a procedure for doing that. How exactly technically is that set up? How is that configured? How are we building that into our overall tag management data collection architecture? Also need to have procedures for deletion of data. So CCPA grants consumers the right to request erasure of any personal information about the consumer which the business has collected from that consumer. Needs to be available, or that option needs to be in there, do not sell my info link on the website. And this also extends, the deletion request extends to third parties with whom the information has been disclosed. This can get really complicated in terms of putting this into practice and making sure that deletion requests are able to be kind of adhered to. It's critical first to understand what personal information is being collected within what platforms, and then digging into each of those platforms to understand how exactly is deletion possible. How are we going to go about and be able to actually respond to and carry out these different deletion requests? So those are the requirements. A lot of times, a lot of the feedback that we get sounds like a lot of legal and security responsibility. We're talking about data breaches, that's more of a security backend thing. We're talking about updating privacy notices and disclosures. It's more of a legal thing. Absolutely wrong. The question is, and what I really want to dig into here today, is how can we, as marketers, prepare the information necessary to make this whole thing work? Ultimately, most of the data collection that's happening across digital properties, across websites, across mobile apps, is a result of marketing needs. We have analytics platforms that are implemented in order to understand consumer behavior, what content's performing the best, how are users interacting with the site, how are users going through our checkout flows, where are the areas in which user experience is getting held up, where can we optimize? We have A/B testing platforms that are in place in order to be able to understand what types of user experiences are better. There's advertising platforms that are in place in order to be able to build audiences, to target our users and other people that are similar to our high value users, to be able to target them in different areas and bring them to our website. All of these different marketing, advertising platforms, ultimately the ownership of these comes back to us as marketers and advertisers. So what can we do to advance our organizational efforts for CCPA compliance? A few years ago, I was at a conference, privacy conference, around specifically for GDPR. So this was before GDPR was going into effect, and a lot of the same topics were similar topics were being covered. How can organizations best prepare for GDPR? And someone had a really good kind of description or an analogy of what can be done to prepare. So ultimately, say you're an adult, you have kids. Your kids aren't able to prepare a full meal for themselves. So say lunch, not able to create a full pizza from scratch. It also can't be necessarily always expected, because maybe you have to go to work, you have other things to really focus on to be able to make that meal for them in every single situation. So the solution is, we can create the pizza, we can make the dough, we can put everything in there, we can put it in the refrigerator. All they need to do is come out, take it, and then finish the job. Put it in the oven, turn the oven on, and then they have the meal prepared for them. That same parallel can be used here for our preparation of the information to then hand off to legal, hand off to security, so they can take it over the finish line and make sure that we are fully compliant. And that's what I really want to dig into here. So how can we get this 80% of the way? How can we get all of the information in an organized fashion to be able to inform the different actions and the decisions that need to be made for CCPA compliance? So what we need to do from a preparedness standpoint today, we really need to understand a list of items. So the first one is understanding all points of data collection on the website. Where is data being collected? Everywhere. Forms, different marketing, advertising technologies, tags that are firing. Any point where data is being collected from our users on the website, we need to understand where those are. Beyond that, we need to understand what are the different digital platforms that are loading on the website. If we have advertising platforms that are loading in other advertising networks and all kinds of other things through piggybacking, through daisy chaining, we need to understand all of those different platforms that are loading. Just saying that, oh, I didn't know that was happening, is not a valid excuse for not upholding the privacy rights of the different users. Once we understand all those different digital platforms that are loading across the website or digital properties, we need to understand for each of those platforms what data is being collected. What is each one doing? And then for any of those, for that data collection, we need to understand, is the data being collected considered personal information as defined in the CCPA? If so, we We need to be able to answer some specific questions about that data and ask certain questions of that data in order to inform what actions we need to take for CCPA compliance. So if we're collecting personal information, what data points specifically are being collected that fall under that definition? What categories, as defined in the CCPA, do each of those different data points fall into? For what purpose is the data being collected? How is it being used? Is the data being disclosed or shared? If so, with whom? Is it being sold? If so, with whom? Is proper disclosure in place? Are we disclosing all of this activity? And then is the ability to opt out clear and easily available? Beyond those last 2 points, these other questions are all things that we as marketers should be able to really dig into and understand for those different platforms, those tags, marketing, advertising technologies that are loading across our websites. We're going to have much better visibility into those different items than, say, legal that's going to be preparing your privacy notice, security that's trying to harden the back end to be able to prevent against any type of data breaches. So we need to gather this information. We need to really audit and inventory the platforms, ask specific questions of each of those different platforms to get all this information in a format that's easily usable for the organization to fully prepare and have the proper requirements and the proper disclosures and safeguards in place before July 1. So how do we do that? So where we start is with a tag audit. So we need to audit and first understand what are the different platforms that are loading, what are the technologies that are loading across our website. These here are screenshots from Tag Inspector, which we obviously use for this purpose. But again, we need to have visibility not only into the things that we're aware of today, so the things that are embedded or loading directly from our website, maybe loading through the tag management system that we're using on our website, even piggybacking activity, even tags, platforms that are bringing their friends to the party that we've maybe never met before. We need to be able to see those things, have that visibility. We need to understand what pages those are loading on, and then we need to dig into what exactly is the data that's being collected. Now, the beginning of the process, what I always encourage organizations to do is really inventory the platforms. So this here is just a screenshot of a very basic tag inventory report. This would be something where we run scans using our tag auditing platform, in our case, Tag Inspector. Out comes all the different platforms. We can see the different tags that are loading. And we first go through a business evaluation. For each of those different tags, let's assign ownership. Who internally is the owner of that platform? Who can we go to in order to understand and really ask the questions about what data is collected, how is it being used? And then also, are there any partners that are involved? Are we working with any third parties that are also helping us or kind of managing any of that information that have access to it? Now, once we go through the business evaluation, that is going to set us up and put us in a position where we understand what are the tags that should be there. Coming out of the business evaluation, oftentimes we're able to really consolidate the overall architecture. We're able to say, these are the things that are allowed. These are the things that I know should be there. These are the things that should not. We can immediately start removing some of the different tags and some of the different platforms from those digital properties. So what it gives us is the foundation, really a V1 of our tag governance policy, our list of approved tags. We can then start really digging through each of those approved tags and approved platforms in order to understand what data is being collected. A few different ways you can go about doing this. You can go about it, again, using a tag auditing platform such as Tag Inspector, where we're going to parse out all of the actual requests. So we're looking at the data being sent from a page and then listing out and showing you what those different data points are. You could also do this consulting the like implementation documentation or technical documentation from different platforms to understand what are the possible data points that are being collected. The most efficient route is looking directly at the data as it's being sent from your website, from your digital properties, parsing that out, really digging into it. So we see all the data that's being collected, those different parameters, those different values, and then we can start asking those questions of each of those different data points that we were talking about earlier. These feed directly into those requirements around disclosure, as well as it informs what are the platforms where we need to be able to have some sort of a technical solution for access requests, for deletion requests, and the like. So this is an example for specifically a Google Analytics tag. You can see all these different parameters. We walk through, answer those different questions that were posed in order to organize all this information. Ultimately, what we then do is we roll this up and we're going to organize it just at the platform level. We're going to have that policy listed out, so our list of unique tags. We're going to have all of that additional context that's necessary in order to be able to take those different action steps that are necessary for CCPA compliance. We're going to have all that in one single document. What we like to do is put that into a tag governance document so it's organized. In that organized fashion, you have everything that you need to be able to hand this over again to some of those other internal teams, your legal team, security teams, in order to be able to then take it across the finish line and be fully prepared for CCPA and be able to really protect yourself against those different enforcement actions that were mentioned. So let's tie this back to those different actions. We go through that process, that auditing process. So we inventory the different tags, we understand what data is being collected, we understand the context that's necessary for any and all of those data points that are classified as personal information. So we think about our core requirements: transparency and disclosure. The tag governance, that audit, and that policy documentation, it informs those disclosures in the privacy notice. Legal can draft up the specific things that are outlining users' rights and things of that nature, and then we can use that information that we uncovered during that audit to inform the actual disclosure and the notification of what is happening to our users. For access rights, we need to first understand what are the platforms where personal information is collected so that we can then inform the technical roadmap for automation of that process. We can understand these are the platforms that are necessary for us to be able to pull these data points from. These are the specific data points and the specific parameters that we're going to need to be pulling out of it. And then we can start looking in for each of those platforms or those vendors we're working with. What is the technical mechanisms via which we can actually execute those different requests? And then how can we simplify, really smooth out that process in an automated fashion? And then finally, similar type of a process there around that refusal and the objection of processing. So that audit, that policy documentation that surfaces the platforms where opt-out technical measures will need to be implemented. As I mentioned before, oftentimes the opt-out kind of mechanisms are going to be to stop at that collection point. So using more traditional consent management platforms, when a user opts out, to conditionally not execute the different tags to which that personal information is being collected. That has some impacts just on general kind of downstream analytics types of things, but it is a safer alternative. We're going to be informed for what platforms we need to address those issues in as a result of that audit that we can go through. So again, when we talk about preparedness, when we talk about what we can do today in order to be able to protect for CCPA going into effect and protect against the possibility of any of those enforcement actions being taken, it's really helping to create that raw pizza and putting it in the fridge so that the other teams internally can then cook it, eat it, and kind of enjoy, be on the way. Let's take it to the 80% and then let the others finish up on the tail end of that. We do that as marketers, and how we help in that entire process is by going through this audit process, understanding the platforms that are loading, and then filling in all that contextual information that's necessary in order to be able to inform the actions that we need to take to be in compliance. So that is the content here today. Let me take a look here at questions. So it looks like we have a few in the chat pane. The one that I always address, yes, the deck and recording will be sent out, so no worries there. Question here, does the gathering of a consumer's IP address or computer fall within the CCPA definition of personal information? If we think back to the definition of personal information, any data point that can be associated with, directly or indirectly, a user or a household. IP address is something that, yes, it's actually explicitly listed within some of the example items in there. So IP address, being that it is unique to a machine, to a browser, that is able to be associated with an individual or household. So yes, that is going to fall under that, that definition for personal information. And as mentioned, it's extremely broad what that personal information definition is. So IP address, along with many other items, are also going to fall under that. So yeah, as always, if any questions come up, especially as you're starting to work through this process, if you start, getting underway in this general audit process in order to be able to really acquire the information and map everything out that you need in order to be prepared for this enforcement period to begin, let us know. More than happy to help. We have a number of different solutions to be able to help with that. So happy to help out with anything. Reach out to us with any questions that you may have. And thank you all very, very much for your time today. Hopefully this was helpful, and hope to see you again on future webinars. Thank you all.